All rise.
Seated. The State of Ohio versus Dwayne Rucker, 24 CR 1136. We're here on two motions. Motion in limine regarding the testing of the substances on the two different dates, and a motion to reveal the identity of the CI and demand for discoverable recordings. Where does that stand, Ms. Smith?
Your Honor, as to the motion to reveal the CI identity and produce the videos of the controlled buys were produced back on March 25th, I believe. The identities of the confidential informants have not been revealed at this time, although there are names associated with those CIs that defense counsel is aware do not correspond with the individual.
Mr. Gregorich?
Your Honor, I will provide. It was under assumption that I told her who it was, but I will provide that immediately following the hearing.
Well, why don't you two step out in the hallway and talk about that right now before we start anything else? Well, I understand. And then subsequent subpoenas went out, I think were served today to show up at 1 o'clock. Is that right?
That is correct, Your Honor.
Okay. So how would I hold Gilson to anything when she wasn't even served with it? It was left at her door, but she wasn't there.
Your Honor, that is in part why we understand the severity and seriousness of asking for a material witness warrant or.
Well, but she hasn't refused to appear for anything.
Welcome back, Courtroom Detectives. Buckle up, because today we're diving into a triple feature straight out of Judge O'Donnell's high-stakes Ohio courtroom. First, we've got a drug lab controversy so messy it could sink an entire case. Then a probation violation where the defendant insists he was doing really good until the meth, MDMA, and bad influences took over. And finally, a mother of two facing her very first felony and the crushing reality of starting over. Judge O'Donnell? He's the perfect storm, razor sharp, fair, and absolutely allergic to nonsense. Stick around, because before this video ends, you'll see why this judge commands respect from prosecutors, defendants, and, trust me, viewers like you. Now, let's step inside the courtroom and feel the tension for yourself.
She received the initial subpoena, which did incorrectly order her to appear yesterday at 2 p.m. She did not appear yesterday.
We didn't have a hearing yesterday.
And additionally, Your Honor, she did confirm receipt of her subpoena on Friday via email on May 30th at 7:23 p.m. and emailed directly to me. Good evening. I received the subpoena.
I saw that because she sent it to Maria also, so I'm aware of that email. But whether she was here at 2 o'clock yesterday or not doesn't matter because there was no hearing yesterday.
And
so she's not failed to comply with anything. I mean, these subpoenas were filed at 11:26 today, telling her, stuck on her door, to be here at 1 o'clock today. Okay, now,
Your Honor, regardless of the subpoena issue, it is the state's burden to produce its analysts to testify to their work.
Let's stop right there, okay? Because this whole thing is ridiculous, okay? The fact that we're wondering where Gilson is, okay, is a big problem for the state, because you should move hell and high water to get Gilson here, because this impacts your lab, okay? The allegations here are deadly serious, that there was a lot of stuff going on there that shouldn't have been going on. Now, whether that is borne out with the testimony, we'll see, okay? But certainly, if the drugs were analyzed by Mr. Meter and confirmed by Ms. Gilson, okay, and the allegation is that they were doing everything wrong over that time period, then, God damn it, I would think that you would want to have her here, and Mr. Meter is here to answer these questions so we can figure out in this case, because this is about this case, okay? It's not about the lab, it's about this case and whether the the correct process was followed, whether they were analyzed properly such that they should be admitted into evidence. So here's what we're going to do, okay? We're going to have this hearing at 8 o'clock on Monday morning, and we're going to start the trial right after that. So I'm going to presume that Ms.
Here's where things heat up. The defense wants the identity of a confidential informant, someone crucial to the drug case. That's not unusual. But notice how the prosecution scrambles over subpoenas that were left on a doorstep just hours earlier. This isn't just legal red tape. The reliability of the entire lab test hinges on the testimony of a single analyst. Without her, the state's case wobbles like a house of cards. Viewers, what do you think? Should a lab tech's absence really threaten to derail a felony indictment? Or is this just the system doing its job to ensure fairness? Comment below.
To give testimony. Because if not, I'm going to presume that she's going to be going to be subpoenaed, okay, to show up at 8 o'clock on Monday, okay? And if she's not here, you know, then we'll have to send somebody to get her. And she'll be here one way or another. But I don't know why it wouldn't be in the best interest of the state to get her here, to give that testimony.
Could I just be heard?
Go ahead.
The subpoenas that were issued for her aren't valid to begin with.
Okay. All right. Then I presume well, I don't know why they're not valid, or whether they're valid, or why are they not valid?
If I might. They were
Well,
issued in the name-
tell her what she did improperly.
Faith Andrews is not the corporate courts.
What?
Faith Andrews is not.
Okay, all right, let's quit screwing around. Mr. Rucker's been indicted, okay? And one of them's an F1, okay? So this is serious shit, okay? So let's quit fucking around, and let's do this the proper way so that case gets adjudicated on the merits. All right?
I agree, Your Honor.
God damn it.
All right.
For a cocktail of drugs when he was arrested.
That is correct. It was May 7th. He tested positive for methamphetamine, benzodiazepine, MDMA, and an antidepressant. We had to test on May 7th.
So there's that violation. You understand that charge?
Yes, Your Honor.
Mr. D, what does he want to do?
He's going to waive his final hearing, Your Honor, and plead guilty to the probation violations.
Is that what you want to do?
Yes, Your Honor.
What's your plea to those violations?
Guilty.
I'll accept your guilty plea and find you guilty. What's the problem?
The problem is, Your Honor, I thought I was doing really good when I...
Boom. Judge O'Donnell drops the gavel, figuratively, and calls the situation ridiculous. This isn't grandstanding. It's a textbook example of a judge demanding accountability. Notice his language: hell and high water, deadly serious. He's not protecting the defense or prosecution. He's protecting the process. And when a judge openly questions whether evidence was analyzed properly, you know the stakes are sky high. Imagine being the prosecutor getting dressed down on the record. Would you double down or scramble to fix it?
I started to stop going to my meetings and things so much.
Why?
And I thought I can do it on my own.
Wait a minute. You were here, I sentenced you on January 24th,
Yes,
and you're not, April 7th, okay? So 2.5 months later, you're not showing up. So you weren't doing good. Don't give me that shit you were doing good, because you weren't doing good. If you were doing good, you would have showed up to decision points. So why don't you comply with what you're supposed to comply with? That's designed to assist you. Why don't you do it?
because I was under the influence again, sir.
Okay. Why?
I just needed more help than I realized.
If what led to all this shit back in January was your use of drugs and alcohol, why did you go out and use drugs and alcohol?
I'll be honest with you, sir. I need more help than I realized, I guess. I don't know. I couldn't answer. I think that it helps me, but it doesn't. And it makes everything worse.
When can you point to any time in your life that the drugs helped you?
And it hasn't. Can't.
So what made you think this time it was gonna help you?
That's my thinking.
Where'd you get the drugs?
From my buddies, well, not my friends, it's my associates.
Who?
There's a dude named David and,
David who?
I don't know his last name. I think it's David, I forget. And then there's a guy that I got it from, another guy, John Mueller and a couple other people.
John Mueller.
Yes.
Why are you hanging around John Mueller? Didn't we have this discussion not too long ago about he's perhaps the dumbest human being alive?
Yes.
Why are you hanging around?
And just like that, the courtroom pivots. One explosive drug lab dispute wraps for the day, and we glide straight into a probation violation that proves addiction rarely takes a day off. Watch how seamlessly Judge O'Donnell moves from high-level evidentiary issues to the gritty reality of relapse. That range, legal precision, 1 minute, tough love counselor the next, is exactly what makes him a standout on the bench.
This stuff.
I really do, Your Honor. I really just want to try to get rehab. I've never completed rehab, and I think it would help me.
Well, where did you go for your IOP after I let you out of here?
Signature Health.
And what did you do there?
I went there. They didn't recommend IOP. They just said to go to meetings, and they put me back in my box, and then that's what got me using drugs again.
Do you have anything from Signature Health? What did you tell them when you went there about your drug and alcohol use?
Your Honor, I lied.
Oh, okay. Well, is it any wonder they told you that there wasn't anything for you to do? Where'd you get your mental health evaluation?
Mental health evaluation, Signature Health too.
Okay, did you lie to them about that too?
Yes.
Okay. Mr. D?
Your Honor, knowing that he needs treatment, the family is here to support him. His mother is here. There's a program called Armada in Akron that would take him. They have a bed available to him, and it would be at no cost to Mr. Dameron. And it could be for up to 1 year, though it's not a secure facility.
It's not a secure facility. Why in the world would I think that he would do it?
He would have the fact that you're going to send him to prison without a doubt.
I could send him to prison right now. That's not an impediment to me.
Prison's not what he needs, Your Honor. He needs that.
Well, maybe it isn't what he needs, but I could send him right now.
You're absolutely correct. You can. And otherwise, NeoCap would be a viable option. He's committed to making the change, Your Honor. And there's the mental health component over at Signature that also would be at Armada. That would be.
Yeah, but
to him.
what good is it to go to Signature when he lies to him?
Well,
This guy's interested in partying. That's what he's interested in doing.
He's always voiced that he didn't need the Suboxone, but they prescribed it to him. I asked him why did he take it if he didn't think he needed it. But he took it because that's what they prescribed, and it led to some of these problems.
And Mueller gave him, whatever he gave him, and so he took it.
Correct. And Tyler knows he needs to change. He just doesn't know how, and he thought he could do it with some outpatient and he could get back to his regular life, but he realized he needs more help than he anticipated, and he's committed to it, Your Honor.
Mr. Deeb, what else you want to say?
If you would be interested in hearing from them, I'd be willing to describe that to you. Other than that, Your Honor, we wait your decision.
All right, I've reviewed the pre-sentence report again and the drug and alcohol evaluation, listened to the defendant and Mr. Deeb. I'm going to keep you on community control. You're going to serve 89 days in jail with credit for 29. The last 30 you'll be in the jail treatment program, and you'll follow all the recommendations. After you complete that, you're going to enter into the NeoCap program, complete it, and follow all those recommendations. And then the rest of the conditions I told you back on January 24th that haven't been completed, with the exception of decision points, you're going to complete all that. You're going to go and participate in everything that I told you to do. Including the no contacts. So do you understand that? I can't send you to a place where you can leave, because you've demonstrated to me clearly that you're not going to do voluntarily
If you give me
what
a
I told
chance,
you
I
to
could show
do.
you.
I just gave you a chance. I gave you a chance on January 24th. After a strangulation charge, I gave you a chance. And you blew it off within 2.5 months. So don't ask me for another I'm giving you another chance. I'm not sending you to prison today. So I'm giving you another chance. You figure out what you want to do with that chance. So if you don't do it, you come back on a violation, I find you violated, and you'll go.
Thank you, Your Honor.
Anything else, Mr. D?
No, Your Honor.
This is heartbreak in real time. The defendant admits drugs never helped him, ever, yet he still went back. That's addiction talking. And when he casually name drops John Mueller, the judge nearly explodes with recognition, calling Mueller perhaps the dumbest human being alive. It's darkly funny, sure, but it underscores a painful truth. Surrounding yourself with the wrong people can undo months of progress. How many of you think Judge O'Donnell's bluntness is exactly what this man needs? Or is it too harsh?
38 years old, Your Honor. She is divorced. She has 2 children, an 18-year-old and an 11-year-old. They're living with her 18-year-old father. Her 18-year-old is going to be graduating high school from Avon High School in New York. If at all possible, she did indicate to me that if there was any way, she would like to be present to attend that. Again, in light of our discussions, it seems that may not be likely, but again, there's that factor. She certainly has that motivation to look forward to stay clean. This is her first felony. She has never been to prison before. It doesn't seem like she has a juvenile record other than a self-reported complicity charge. Other than that, there's no other juvenile record, Your Honor. She does not have a valid driver's license. She owes license fees. I asked her, of course, what she does for a living and confirmed that per the pre-sentence report, she is self-employed as an in-home caregiver. Of course, my follow-up question was, how do you get to the homes of the people you're providing care for? She said she takes Uber. I then said, would it not be more beneficial to you to save your Uber money to go towards your fees for your driver's license so that you don't have to continue to rely on Uber to get to that job? She agreed with me. So one of her goals then would be to obtain her driver's license, to obtain her GED. She only completed the 9th grade at Euclid High School. So that is a goal that she'd like to accomplish as well, potentially getting her opportunity for better employment. She indicated that the individual that she was with at the time she committed this offense was a person that she met at the jail. They exchanged numbers, went shopping together, became friends so that they could abuse substances. So she knows that she needs to make better friend choices. She does take responsibility in that she knows and recognizes she has her substance abuse, so her desire to attend NeoCap and or do another jail treatment program, she's willing to do those things, Your Honor, so that she can better herself and demonstrate to the court that she can leave the drug life behind.
The defense makes a passionate pitch, a year-long treatment program with a family ready to help. But here's the catch. It's not a locked facility. For someone who's already blown off court-ordered treatment, that's a big risk. The judge knows it. Notice how he keeps the pressure on. I could send him to prison right now. That's not empty talk, it's leverage. He's testing whether the defendant truly wants recovery or just another easy out.
Up in this sort of environment, as evidenced by the death of several of her family members, Your Honor, including her father, who, as I understand, died of an overdose, her 2 sisters that she's lost. So she's also indicated in the pre-sentence report that she would like some grief counseling. She's never squarely dealt with the death of several of her family members, Your Honor. So she has a lot of things that she'd like to consider. So again, I asked her specifically what her goals were, other than just what the court might hear from many defendants, which is, well, I just want to change or be a better person. When I asked her how she wanted to do that, she did tell me that she did want to increase her education level, get her driver's license back, get a better job, be there for her children, stay away from the people that provide her the opportunity to continue to abuse substances, Your Honor. Furthermore, she is, and indicated to me, that she is in contact with Signature Health at Willoughby with an individual named Nicole Pavella. She wants to continue her involvement with Signature Health. She indicated in her pre-sentence report she wanted to do virtual substance abuse classes. I said that's not going to fly. That's another reason why you need to get your driver's license. And until then, if you're going to do treatment, you need to get there in person. So she's got a lot of things that she's hopeful to look forward to, Judge, and she understands that the court certainly has every right in